Good evening, everybody. Keith here again. Hoping everybody's having a good day, enjoying life, living life, loving life. Wanted to get on and talk to everybody again about the Foreign Sovereign Immunities Act real quick. Hopefully quick anyway. But when we talk about the Foreign Sovereign Immunities Act, we find it in Title 28 of the United States Code, which is the Judiciary and Judicial Procedural section. And under that code, Chapter 97, we talk about the jurisdictional immunities of foreign states. That's the Foreign Sovereign Immunities Act, and it runs from Section 1602 to 1611. And when we click on that, it starts out, it tells you 1602 is the findings and declaration of purpose. And it says here, the findings and declaration of purpose. The Congress finds that the determination by United States courts of the claims of foreign states to immunity from the jurisdiction of such courts would serve the interest of justice and would protect the rights of both foreign states and litigants in United States courts. Under international law, states are not immune from the jurisdiction of foreign courts insofar as their commercial activities are concerned. And that's pure and simple. They're not immune when it comes to commercial activities. And their commercial property may be levied upon for the satisfaction of judgment rendered against them in connection with their commercial activities. Claims of foreign states to immunity should henceforth be decided by courts of the United States and the states in conformity with the principles set forth in this chapter. So you see, it's really short, concise. And then the next section is section 1603, which is the definitions. And this section here is also kind of short. So we're just going to kind of read through it for now, and you guys need to research it and see what these blue underline highlighted links are about. I'll go through and do one or two of them when I'm done here reading it. But it says definitions: for the purpose of this chapter, a foreign state, except as used in section 1608 of this title, includes a political subdivision of a foreign state or an agency or instrumentality of a foreign state. And remember, I spoke earlier about the instruments. Instruments are financial debt notes. They're commercial in nature. And so they're saying agency, which would mean on the diplomatic side of a government, and instrumentality would be on a commercial side. Agency or instrumentality of a foreign state as defined in subsection B. And so when we go to subsection B, it says an agency or instrumentality of a foreign state means an entity, one, which is a separate legal person, corporate or otherwise. Two, which is an organ of a foreign state or political subdivision thereof, or a majority of whose shares, commercial, or other ownership interest is owned by a foreign state or political subdivision thereof. Three, which is neither a citizen of a state of the United States, as defined in section 1332 C and E of this title, nor created under the laws of any third country. Okay. Then it says the United States. It includes all territory and waters, continental and insular, subject to the jurisdiction of the United States. So the only ones that are subject to that jurisdiction wouldn't be the places themselves. It would be the people that are performing trade or business of public office. That would mean your distributors, people that acquisition things, anything to do with debt instruments, the commercial side. And this is where we see the thing about the Clearfield Doctrine. Once they step down into the commercial capacity, they lose all their immunities. They are now, you're now able to file suit against them in their personal and private capacities for that commercial reason. Then it says, D, a commercial activity means a regular course of commercial conduct or a particular commercial transaction or act. The commercial character of an activity shall be determined by reference to the nature of the course of the conduct or particular transaction or act, rather than by reference to its purpose. This is where the intent comes in. If your intent is to perform a public commercial act, all public acts and deeds shall be recorded. Therefore, they have a right to record the information. However, if you're operating in a private capacity, whether it be business affairs or private, personal affairs, family affairs, it doesn't matter. It's none of their business. It's none of their trade or business. It doesn't have to do with their commercial system if you're bartering on a private basis. Now, just because a barter might include Federal Reserve notes doesn't mean that they have the authority now to step in and claim third-party participant. They can't do that. That isn't the nature of the transaction. Then it says a commercial activity carried on in the United States by a foreign state means commercial activity. Period. Carried on by such state and having substantial contact with the United States. So if I'm just traveling in the United States and there's no commercial activity, can any of their police officers whatsoever pull me over simply because I'm in their territory? No. Because even then, their codes and statutes and everything only apply to them. I still have a diplomatic immunity because I am not performing commercially. Period. Okay, and that's section 1603. That's the entirety of the definitions. Told you it wasn't going to be long, especially compared to various other sections. But now we're going to go back to section A of this, because here it says a foreign state, except as used in section 1608 of this title. And we're going to check that out because that's important here. But I'm going to finish reading this for you again. A, in definitions, for the purpose of this chapter, A foreign state, except as used in section 1608 of this title, includes a political subdivision of a foreign state or an agency or instrumentality of a foreign state as defined in subsection B. And then you go down and you look at those, and it says except as used in section 1608. So here we're going to look at it at the exception. And in 1608 it says service, time to answer, default. Now, why would it have something in there in regards to state? If we look back at 1603 in definitions, that's all we're talking about is definitions, and it says a foreign state, except as used in section 1608 of this title. So when we look at 1608 of this title and it says service, time to answer, default, what are we talking about? We're talking about some kind of acceptance. Service in the courts of the United States and the states shall be made upon a foreign state or political subdivision of a foreign state by delivery of a copy of the summons and complaint in accordance with any special arrangement for service between the plaintiff and the foreign state or political subdivision. Or, if no special arrangement exists, by delivery of a copy of the summons and complaint in accordance with applicable international convention on service of judicial documents, or if service cannot be made under paragraphs 1 or 2, by sending a copy of the summons and complaint and notice of suit together with a translation of each into the official language of the foreign state. What's the official language here, people? I believe it's English. It's not the Chicago Manual Styles. It's not any kind of manual styles except concise English. Official language, concise English. By any form of mail requiring a signed receipt to be addressed and dispatched by the clerk of the court to the head of the Ministry of Foreign Affairs of the foreign estate. Or, if service cannot be made within 30 days under paragraph 3, by sending 2 copies of the summons and complaint and a notice of suit, together with a translation of each in official language of the foreign state by any form of mail, requiring a signed receipt to be addressed and dispatched by the clerk of court to the Secretary of State in Washington, District of Columbia, to the attention of the Director of Special Consular Services, and the Secretary shall transmit 1 copy of the papers through diplomatic channels to the foreign state, and shall send to the clerk of court a certified copy of the diplomatic note indicating when the papers were transmitted. As used in this subsection, a notice of suit shall mean a notice addressed to a foreign state and in a form prescribed by the Secretary of State by regulation. Now, they just prescribed this, that a copy, by delivery of a copy of the summons and complaint in accordance with any special arrangement for service between the plaintiff and the foreign state. Let's see, Title 22 of the Code of Federal Regulations 93.1. Service through the diplomatic channel. The Director of the Office of Special Consular Services in the Bureau of the Consular Affairs Department of State. The Managing Director of Overseas Citizen Service shall perform the duties of the Secretary of State under Section 1608A.4 of Title 28 of the Codes. So when we look at Title 4, it says if service cannot be made within 30 days under Paragraph 3. It says Paragraph 3, if service cannot be made under Paragraph 1 or 2 by sending a copy of the summons or complaint and a notice of suit together with the translation of each into the official language of the foreign state. I've never gotten a summons or complaint in concise English. It's always been in legalese. Always. Every last one. Every last one. Language is key, people. I'm telling you, language is key. So then we look at, if no special arrangement exists, well, there is the special arrangement. The special arrangement is that when the clerk of court concerned sends documents under 1608A.4 of Title 28, the Managing Director of Overseas Citizen Services shall promptly ascertain if the documents include the required copies of the notice of suit and of the summons and complaint or default judgment and any required translations. If they have filed anything in legalese but not in concise English, then they have failed this part. It is a fatality to their filing of a suit. Period. And this is your Foreign Sovereign Immunities Act at work, people. Title 28 of the United States Code, part of the Foreign Sovereign Immunities Act within section 1602 to 1611. At 1608, it tells us service time to answer default. Right there, the service terms and conditions of the state plaintiff having to serve papers on myself have to go through diplomatic channels that are already provided for. And that means the clerk of court is to notify, once they receive a complaint from the prosecution, that they are to notify the counselor, the Bureau of Consular Affairs, to the U.S. Department of State, that they have received a suit filed upon a foreign state. They're not doing that. Why? Because they filed it upon a United States state citizen. And you're claiming that it's you. I'm sorry, I beg to differ. I'm a foreign state. I have sovereign immunities, and you have to give me diplomatic service, because I know for a fact through the Social Security Administration, the Social Security Act, the Social Security application, I'm known as the authorized representative as long as I clarify that. Now, whether I've done that on paper or not makes no give a damn rat's hoose. I've done that publicly here on video many times. I know I'm the authorized representative. I can stand in any court and prove it by their own presumption, because all of the banking transactions that I've filed or transacted with the signature on a check is written on a supposed signature line that says authorized signature. So whether I correct the SS5 application or not, in literal sense of writing, I don't have to. I can clarify that verbally. I'll have you record that on the record. We're on it for your record here. You better get it clear, because it's in my record. It's in my record. I'm the keeper of my records. Did I not just state my record verbally? Would you like to open my record and be subject to the fee schedule for viewing my documents? Here, let me write one up real quick. It'll cost you. You got to think about this stuff, people. So when it comes to the Foreign Sovereign Immunities Act, we really have to think about this and realize what we're reading into here, what they're using against us, and how to use it against them. So when we look at the definitions at 1603 and then we jump to 1608, it says service time to answer default. We're going to turn around and it says 1604 is immunity of a foreign state from jurisdiction. And this is a very, very short one. Subject to existing international agreements. What's an international agreement? Isn't that a treaty? Isn't that a treaty of peace? Subject to existing international agreements to which the United States is a party at the time of enactment of this act of foreign state, shall be immune from the jurisdiction of the courts of the United States and of the states, except as provided in section 1605 to 1607 of this chapter. When we look at 1605, it says general exceptions to jurisdictional immunity of foreign state. And when you read that, this one's a little bit longer. I'm not going to read it. But when you read it, you'll see it has to do with commercial activities. That's 1605 for the general exceptions. And when we look at 1607, counterclaims, I guess we should look at 1606 here. 1605A is terrorism exception to jurisdictional immunity of a foreign state, and that's where they're going to try that acts of terrorism on you. So we have to make sure we understand, we comprehend the writing there as well. Responsibility of foreign states for international terrorism against the United States, and that's in conjunction with section 1605A. This is 1605B, and that's where we when we establish our private member association, as I spoke of in my earlier video, we have to do it on an ecclesiastical format, promoting peace and love. And when we do that, we keep ourselves from being involved in verbiage of attacks by claiming that we should be going to war or anything like that. There are certain things we need to stay away from. And like I've professed many times, mankind's most powerful weapon is his mind. It's his most powerful tool. And if he uses it wisely, we don't have to go to war. We don't have to fight. We don't have to get physical with each other. Sun Tzu's Art of War says to defeat one's opponent without fighting is of supreme excellence. And that's true. In beginning was Word. And if we can live in peace and love by the Word, then we don't see all this corruption and everything. And that's what we need to get back to. And that's why it's important to learn this stuff so that you can pronounce it. So you can announce it. So then we look at 1606, and it says extent of liability. So we're going to take a look at that real quick. And extent of liability, it says, as to any claim for relief with respect to which a foreign state is not entitled to immunity under section 1605 or 1607 of this chapter, the foreign state shall be liable in the same manner and to the same extent as a private individual under like circumstances. But a foreign state, except for an agency or instrumentality thereof, shall not be liable for punitive damages. In other words, they can't be liable for property damages. Okay? And this is where we're gonna talk about the Clearfield Doctrine a little bit. Because this is in regards to like public officials acting in a corporate manner. They're no longer immune. They are now subject to contract law. And what they're doing here is stating that though they're not immune from the law, the punitive damages can't be held against the government property. Okay, it can't be held against the government office. The only thing you can get for relief out of the government office is a balance of the ledgers and a compensation thereof of violation of your or trespass of your rights or whatnot through your tort claims. And that's done through your personal capacity. In your private capacity, you have a right to punitive damages, but you can only do that through their private capacity as well. So you have to go to them man to man through a court of arbitration, which gives you access to your court of federal claims. So you can actually sue another man. Otherwise, your arbitration in a court under 9 U.S.C. Title 9 of the United States Code is a court of arbitration to clarify the different parts of the Clearfield Doctrine and how it works both in the personal and private capacity. Because, again, you can't sue a government entity in their private capacity. Therefore, you can't get the punitive damages. You can get compensated through the zero value of their Federal Reserve notes. But can you call that punitive damages? You have to turn around and use those Federal Reserve notes within their financial corporate debt system again in order to get any kind of compensation. Whereas you have a lawful right on the private side of compensation through substance, such as the gold clause that I talked about earlier in my previous video. You have a right to punitive damages on the private side of a substance. And if you're going to claim that substance in their private capacity, you can't go after them for Federal Reserve notes. You comprehend that? You have to force them to auction off their property. You have to go after their property collaterally. In your personal capacity, you go collaterally for the Federal Reserve notes. In your private capacity, you go after them collaterally for their property. And you can do this if you do it right. You can, depending on how much they actually own lawfully, you can technically wipe out a nation. Depends on how big that nation is and how fierce you want to go after them. And so it's very important and to understand your own liability. Remember, I talk about the Uniform Commercial Code 3-402B section or subpart 1, where it talks about the authorized representative giving an unambiguous authorized signature on the instrument is not liable for the person named in the instrument. And here we're talking about the extent of liability. And so when we talk about the extent of liability in this Foreign Sovereign Immunities Act, we're talking about their public liability. We're not talking about our liability because we've already been told we're not liable as the authorized representative. So we are, in fact, immune within that commercial system. And this is their catch-22. If we're immune in their system and they're using it against us, even though we know that we're immune, then we have a tort claim. They are administrating affairs against us and causing us harm and detriment, even in our private capacity, because they're not allowing us to use their own construct of that commercial system the way it's meant to be used, and thereby telling us that we're subject to it. We have to follow by those rules, but then don't allow us to follow by those rules. You know, they don't allow us to assert our right of enforcement. And so once you learn this stuff, this is your right of enforcement. You learn how to flip the tables on them. You say, well, this extent of liability clearly says that as to any claim for relief with respect to which a foreign state is not entitled to immunity, you're the foreign state in regards to myself. In your private capacity, you're not allowed immunity because in your private capacity as a man, you're the ones that created the acts. Despite your judicial capacity of performance in a public office for trade or business, you use that trade or business against me in my private capacity. And that's a no-no. I have foreign sovereign immunities in regards to that. I'm going to use it against you. So we really have to look at this stuff and read. A lot of this stuff really isn't all that long, you know. When you look at this stuff, and in 1605 or 1608 service time to answer default, that's in relation to both, like I said, your Title 22 of the Code of Federal Regulations 93.1, where they talk about diplomatic service. Let's see here. We're going to do 93.2. That's the next one. Let me see. Under definitions in this Foreign Sovereign Immunities Act, I want to show you the tie-in in regards to naming that person as a corporate entity. In definitions, under B, it says an agency or instrumentality of a foreign state means any entity which is, number one, which is a separate legal person, corporate or otherwise, and two, which is an organ of a foreign state or political subdivision thereof, or a majority of whose shares or other ownership interest is owned by a foreign state or political subdivision thereof, and which is neither a citizen of a state of the United States as defined in Section 1332, subsection C and E of this title, nor created under the laws of any third country. Okay, so this was a person, a corporate person that was created under the United States. And it is a political or subdivision thereof, known as part of the public charitable trust, of which you are a foreign organ. You are an organ of that. You are a living organism. And it was created in your name, and therefore you have paramount ownership rights or ownership interest in the rights of that person, in the privileges and rights of that person. Civil and personal, corporate, whatever. On top of that, you have your unalienable common right to all man. And that's RITE. So we have to think about this stuff and realize and understand that that there is in conjunction with 22, Title 22 of the Code of Federal Regulations, Section 93.2. And we're going to talk there. Notice of suit or of default judgment. A notice of suit prescribed in Section 1608A of Title 28 United States Code shall be prepared in the form that appears in the annex to this section. Annex, relevant only if 4 items. Notice of suit or of default judgment. Number 1, relevant only if items 4 and 6 indicate that a default judgment has occurred. 4 is the nature of documents served. Example, summons and complaint default judgment. Notice of documents served, right there. First off, were the documents properly served through diplomatic channels of notice? No. So right off, it says only if items 4 and 6 indicate that a default judgment has occurred. First of all, there's been no service, so it can't. 6, date of default judgment. Again, there's been no proper service, so there can't be a date. It's an invalid date. It's an invalid service. Everything about it is invalid. So when we talk about a notice of suit prescribed shall be prepared in the form that appears, if there's no service, then there is no notice. If there's not proper service, then there is not proper notice. We have to comprehend this stuff, and that's why that they talk about that a receipt for registered mail. You have to have when they send us a service of notice, we're supposed to get something to sign as a receipt that we received notice. If we get something in the mail that's in a windowed envelope, says clerk of courts and blah, 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 summons, sorry, improper service. Send it right back, improper service, Title 22 of the Code of Federal Regulations, 93.1 and 93.2. Foreign Sovereign Immunities Act, Title 28 of the United States Code, Title 28 of the United States Code, Section 1602 to 1611. Please be informed. You've now been given notice. I assert the forthright common right to be given diplomatic notice as a foreign state. So, again, I hope this helps you guys figure this stuff out in relation to your PMAs and all that. It's important to comprehend your foreign state status, and when you get ready to do that, this is one of those elements that you really want to put in there and comprehend what it means. Comprehend how to use it. Know where it's uniform within the code. This is a United States Code, and then the other one is the Title 22 of the Code of Federal Regulations. These are talking about notice of suit. You've got the Foreign Sovereign Immunities Act, Title 28 itself, stating that you're not liable as a foreign sovereign unless you're performing commercial activity. But if you're not performing commercial activity, you have a valid claim against a government entity that is enforcing a valid contract on you, because you have a right to be secure in your person under the Fourth Amendment of the United States Constitution. Right there's your parallel right there in regards to Foreign Sovereign Immunities Act. And then your Title 22 of the Code of Federal Regulations says you're not liable, or that you've got to have diplomatic service of notice of suit. And if you haven't gotten that, then how could you possibly be liable? Along with the fact that the Uniform Commercial Code, again, through the Federal Reserve Act, which has the Foreign Sovereign Immunities Act in it, and the Social Security Act, which is the setup of transactions that assigned you through the Social Security application as a authorized representative. because through all banking instruments, you are presumed to be the authorized representative. Ask any banker. Ask anybody that's accepting that check from you when you sign that check and deposit and endorse it. Ask them if they believe that you are the authorized representative. You can get any banker to sit on a stand and state that anybody that signs a check, they believe them to be an authorized representative unless they're presenting a counterfeit note or an ID, you know. And so we've got to get down to the point to realizing who we really are. Know who you are. Are you a foreign state according to this corporation? Are you a foreign state according to that clown sitting on the bench? Are his acts being done in private? Is he using his own private motivations? Does he have some kind of bias? Of course he does. He's acting commercially, and that automatically drops him, or lowers him to the status of a private entity, private citizen, and therefore he falls within the abilities of being able to file suits against him, both personal and private capacity. So think about this stuff, learn it, comprehend it, get your PMA set up. And like I said, it's going to be a while before I do another video on the PMA information, but get started on this stuff and comprehend that foreign state status and how important this Foreign Sovereign Immunities Act plays in it. This is very pertinent information. It tells you that there's a separation of powers with the Commerce Clause in the Constitution. And you'll see, I believe in my last video, I'm hoping Don Nordhoff saw it, and we'll post some information there. But as well as on my post of the foreign state status, he posted a lot of good information in there in regards to your information available to discern the different quotations on what a state and what foreign states are and what the United States is and how to discern all that stuff. And a lot of good Supreme Court cases are listed there. He's a great source on knowing who you are in regards to foreign state status. He's got quite a bit of information on the Lieber Code as well. So listen to that guy and read that information. If you have questions, feel free to ask him too. I'm sure he'll be glad to help. You'll see him. He's posting lots of information on that post of mine for the notice of foreign state status, and it's all good information that expands upon the notice that I gave. So think about this, and again, don't use that notice yourself. That's just information to help guide you in your research so you can discern for yourself how to construct your own. You cannot use that. That's the wrong format and everything. So again, remember people, if it wasn't for you guys, I wouldn't be doing this. God bless you. Love you. Have a great night. Bye.